Good afternoon. Happy Tuesday, part two. People in my Discord are discussing Coke bottles as they relate to Earl David Warden. And so I figured I'd have a little palate cleanser. And I was looking through my comments, and a lot of people were talking about this motion that Chille copied. You don't plagiarize motions. I mean, you have to adapt them to your facts. So it's never plagiarized. And it's what you do. I mean, I you don't reinvent the wheel every time your client wants to do a motion. You find a similar motion that you've done and scavenge the law from it, put in your facts, the new facts, and bada boom, bada bing, you've got the new motion. Or you find someone else who's done it. And again, you repeat the same process. As long as they have the correct law in there, you just plug your facts in, and then you have your memorandum of points and authorities for your motion. So what Chille did is Chille found the memorandum of points and authorities for someone who had their motion granted by Judge Burroughs. Phenomenal. It's a good process to do. Now, why wasn't Chille's motion granted? Well, I haven't actually seen the motion that Chille plagiarized from, that he copied. I say plagiarize. I don't mean that in a negative sense. I mean, it's a perfectly valid thing to do. And if Chille did it more often and he understood what he was reading, then he'd probably have a better chance of well, it's a garbage lawsuit, but he would sound smarter while he prosecuted a garbage lawsuit. Anyway, so why would it have been granted before, but not for Chille? I mean, we're assuming that the judge is not biased against Chille at this point. She's not going to make an error of law just because she doesn't like the cut of Chille's jib, right? She's going to make a ruling based on the law. I mean, her like or dislike of someone might tip the balance ever so slightly, but she's not going to just flat out ignore the law because she doesn't like Chille. So why? Get to the point, John. Get to the point. So there are two possible reasons that I could think of. And they both stem from the problem that a memorandum of points and authorities have to have two things in it. It has to have the facts and it has to have the law. Now, the easiest way that we can suggest that the court would have come to a different conclusion is if they're different facts. The likelihood that you have the same facts, I mean, an identical fact pattern, is somewhere in the slim to none range. You may have similar facts, but you probably don't have identical facts. I mean, it just doesn't work that way. It's theoretically possible, but realistically, it's not going to happen. So the question would then become, are your facts similar enough to the facts that were in the original motion that was granted for the court to come to the same conclusion? Assuming that the facts are different, then I'm going to say no, it does not appear that they were similar enough that the court could come to the same conclusion. I read the motion and I loved the citations, and I loved the fact that he looked up case law, or it appeared that he looked up case law. Somebody looked up case law and provided appropriate citations. And yet it wasn't compelling. To me, it didn't look like he had met his burden by showing that the facts supported his conclusion. It's like if you have instructions for Legos or something, some other toy that you might be getting your child for Christmas. If that toy comes with instructions for assembly, if you don't have all the right pieces, it doesn't matter if you have good instructions for assembly or not. You're not going to be able to put it together. You're not going to get a working toy out of it. And the facts are like the pieces, and the instructions are like the law. So if you put the facts together, following the instructions, if you don't get the toy, then you don't have the right parts. Or if you don't have the right instructions, but you do have the right parts, you also won't get the right thing. But the judge is probably going to be smart enough that she's going to know the right instructions to follow because she has a law clerk and she's been doing this for decades or so. And so she's probably going to be able to be like, yeah, you have all the right parts here. Let me show you the correct way to construct it. So all Chille really needed to do, he didn't really need to state the law, because the court's going to give him a lot of leeway as a pro se litigant, a lot of leeway in that aspect of not knowing the law. The court isn't going to expect him to know the law and provide a really great legal brief on the law. What the court is going to expect him to do is to provide all of the relevant facts. That's his burden. His burden is to give the court the facts. So one way that we've established that the court might rule against him is if he had different facts that were sufficiently different enough from the facts in the original motion that would merit a change in outcome. The other way that it might get a change in outcome, let's assume they are identical facts. Well, why might Chille's motion have been denied? Well, it's because the judge gets to determine what the facts are. You say, these are the facts, right? You've said, the facts are A, B, C, D, E, right? You've listed them off. The judge then gets to read those, and the judge gets to weigh each one of them for credibility, for reliability, for whether or not, for how useful she thinks it is to apply to the law. So the judge gets to make these determinations. The judge in a motion hearing is the finder of fact, as it were, and gets to make those kind of credibility issues. So even though you might recite facts that are identical to what someone else recited and got their motion granted, if the judge doesn't believe you, then the judge might not believe your facts and might deny the motion. If the judge weighs the facts differently for you, I guess if it's identical, the judge wouldn't weigh them differently, because that would be a question of difference. So credibility or so it probably, I got lost there. I'm sorry, but I'm cute. So the judge might weigh the facts differently, and based on how the judge determines those facts to be, based on what you've said, based on what oppositions are, etc., the judge can come to a different opinion. Like if, say for example, if Dr. Law told you that you can get trespassed from a public building even if the building isn't closed to the public at that time, and I told you you can get trespassed from a public building even if the building isn't closed to the public at the time, it might be different coming from me or Dr. Law, depending on who you believe more, when we say that fact. And you might weigh and judge that fact differently based on who is saying it. Similarly, the judge can weigh and, assign credibility to facts stated by Chille as opposed to some other person who she finds to be more credible. So there you go. That was a long-winded way of saying that, number one, just because Chille copied the motion doesn't mean he's a plagiarist. I mean, it's just what you do in the legal world. You don't reinvent the wheel. Number two, just because Chille copied the motion that was granted in the past doesn't mean that he has the same facts, and the facts are the important thing. The facts are the operative thing in order to get the motion granted. And number three, even if he had the same facts, the court could weigh them differently based primarily on the credibility of the person asserting the facts, i.e. Chille. She might find him to be less than credible, and so discount the certain facts that would be necessary for her to grant the motion. So I hope that makes sense. I don't think it's going to be useful for getting the judge recused just because she granted a similar motion, not the same, similar motion in the past. Doesn't mean she has to grant it. The Court of Appeals would look at it for abuse of discretion. They would assume all the factual findings necessary, discounting of credibility and things like that, in order to see if they could support the denial. I think from my reading of it, it should have been denied. It was denied. And so there you go. Thanks for watching. Have a great day.